Hello, welcome to this mini lecture on the common law and the environment. As I've already mentioned, this is one of the foundational set of principles on which modern environmental law is founded upon or is based on. And our quick coverage of this is intended to be largely a review rather than a substantive introduction. Now, to the extent that you've not covered these doctrines in your torts or property class, feel free to check in with me and I'd be happy to spend a little bit more time on these. The four primary doctrines that are most important and that I'll be going over or reviewing here are strict liability for extremely dangerous activities, trespass, private nuisance, and public nuisance. Now, that is not to exclude, of course, the relevance of other tort principles. For example, strict joint and several liability is an important doctrine or principle that has a very important place within the Superfund statute. But by and large, many of these really sort of pervade environmental law. These four that I've just mentioned really are foundational in the sense that they've been primarily relied upon by judges and by the government and by private individuals to address pollution and environmental degradation issues prior to the advent of the modern environmental regulatory system in the 1970s. Right, so let me go ahead and start and go through some of the slides that I have. As I said, please keep in mind that this is supposed to be a fairly compressed overview, and hence I'm not going to be delving into a lot of detail on any one of these doctrines, although I invite you to check in with me about any questions or additional details that you might be interested in. Right? So, as I've already mentioned, the four doctrines that I'll be covering are strict liability for abnormally dangerous activities, trespass, private nuisance, and public nuisance. Now, to start off with abnormally dangerous activities, strict liability. If you recall from your torts class, this actually has even a longer or an origin that is much deeper in the common law, and that it arose out of Rylance versus Fletcher and ideas about wild animals. And over the course of the last century, certainly, it's evolved quite a bit. I'm really referring to the American version here. The versions that the American Law Institute has embodied within the restatement, first, second, and third. And the third restatement version of the abnormally dangerous activities, strict liability doctrine, has come back sort of full circle almost again to the initial version that came out of Rylance versus Fletcher. And essentially it has three elements, right? It looks to an activity first that is foreseeable and has a highly significant risk of physical harm. So it's something that we know is inherently dangerous, right? Not something where harm arises unexpectedly. That would be covered under traditional negligence principles and would not qualify largely because the very idea of strict liability is that this is something that is well known and unavoidable and therefore should be expected and therefore is something that the person responsible for the activity should anticipate that harm will arise and that therefore they should anticipate some amount of liability. The second element here is that the harm or the danger cannot be eliminated even with reasonable care, right? And that is sort of part, to some extent, of that idea of extreme or something that is abnormally dangerous, that it can't be made safe. Now, I would point out that some of these, of course, the idea really focuses on the activity generally, not any specific conditions. So, of course, driving 150 miles an hour in a busy street might be deemed to be abnormally dangerous. But to the extent that you define it that narrowly, almost anything becomes a quote-unquote abnormally dangerous activity. And I think the better definition, the way the common law or the way the restatement would look at this is really the activity is that of driving, and driving can be made safe, or at least reasonably safe, by taking various precautions, including driving within a reasonable speed, having a well-equipped car with good brakes and paying attention, etc., etc. Right? The alternative would be something like transporting dynamite, where the material itself is so explosive and inherently risky that no matter what you do, however careful you might handle it, it just comes with that risk of significant injury or harm because of the explosion. And then finally, the third element here is that it's not something of common usage, right? Something that is not done in day-to-day activities, and therefore is justified to be something that where we might depart from our usual notions of culpability, right? This is something that does come up in the context of hazardous substances, dangerous chemicals, where we look at that activity, that is the use of those chemicals, and deem that to be just something unusually harmful or dangerous, and therefore justifiably making it subject to these strict liability principles. I won't go much through here the defenses here. For our purposes, as a general principle, it's not particularly significant, but there are defenses to strict liability for abnormally dangerous activities, including assumption of the risk and comparative negligence, for example, and also this broader issue of scope of liability and foreseeability, right? How foreseeable was that particular harm for the plaintiff, right? Varies across the jurisdictions, but I won't get into any more detail. The second set of important doctrines under the common law that is significant for our purposes is trespass, and I contrast it here with private nuisance. Trespass is really most straightforward, something that you should have encountered in property and in torts. Essentially, when somebody intentionally enters another person's land or puts something onto another person's land, and where that other person's land, where the other person essentially has ownership and therefore the right to exclusive possession and the right to exclude everybody else. And so your entering is a trespass because it violates that right to exclusion. As I said, it includes both entering as a person or leaving or putting something there. And that is, of course, important in the context of pollution, when pollution particles, when contamination, when dangerous substances can be put onto another person's land, that can be give rise to a trespass claim. And that includes not only putting something onto another land, somebody else's land, but leaving it there. So you may deposit an object onto another person's land by their permission, but once they withdraw the permission, which they may be able to do, the continued leaving of that object or the substances there, that becomes then a trespass because the permission, the consent has been withdrawn. Right? This is articulated in Section 158 of the Second Restatement of Torts. The third concept or doctrine of the common law that is particularly relevant to the environment is private nuisance. Private nuisance, like trespass, is directly associated with private property ownership. And in contrast to trespass, it is an interference with the right of the property owner that does not involve a violation of their right to exclusive possession, but rather violates their right in the private use and enjoyment of their land. So trespass violates the right of the property owner to exclude other people and other things, whereas private nuisance violates the right of the property owner to their use and enjoyment of the land. And that may be, living there, using the outdoors, using the yard for family gatherings, for barbecues, for just relaxing, because, and as this comes up in the pollution context, because of nauseous odors, of pollution that comes in the land, and therefore you can't breathe properly because noise makes it impossible to sleep at night, or dust that comes onto the land that also makes it impossible to be outside without adverse health consequences, or just having it bother you and making it so uncomfortable that you can't really be comfortable outside, or not to be able to sleep for that matter because of noise, or leaving your windows open because all the dust, for example. So that is, of course, a direct relevance. I do want to point out that I have a bunch of slides here on private nuisance because it is a more complex doctrine. It is relevant, continues to be particularly relevant nowadays with regard to pollution and environmental issues. as does public nuisance. But private nuisance is more of use, of course, to private property owners, to private individuals, as opposed to public nuisance, more relevant to the government, but also to public interest organizations suing on behalf of sort of the broader public interest and a community, not just a particular individual, usually, right? Private nuisances may be intentional. Where's my pen here? Maybe intentional and relate to unreasonable conduct, and I will come back to this in just a minute, or unintentional, but otherwise actionable because there's some culpability element involved. That is, the activity is either negligent, reckless, or subject to some sort of liability under ordinary abnormally dangerous activities. How do you want to keep these apart? Intentional nuisances can arise, of course, when somebody intentionally is trying to prevent a property owner from being able to sleep at night to enjoy the outdoors. I purposefully put dust or make it create nauseous odor. I will say that that's actually not that common. What's more common is that the intent can be proved by the failure to abate an activity that causes an interference with the other person's use of the property. That is, odors may be present not because the neighbor purposefully creates these odors from a pigsty or a fire, a fire in the backyard that they run 24 hours a day. Maybe not a fire, but maybe some sort of a backyard operation, a backyard smelter, and they refuse to abate it after they've been told by the neighbor that it's bothersome. How does it become intentional? Remember from your tort law that intent can be shown not only by purposeful conduct or by purpose on the part of the tortfeasor to cause a particular harm, and here the interference, but also by engaging in the activity and not stopping it, even though you know that that particular harmful conduct or harmful outcome will arise. So once you've been told by your neighbor that the odor or the smoke is bothersome, and you continue to engage in that conduct nevertheless, you continue to engage in that activity that causes that nauseous consequence, that becomes intentional conduct, right? That is how intentional, that first prong here can be captured. The other second prong here arises when activity may in fact not be intentional. I negligently cause a fire in my backyard, and it causes just a lot of nauseous interference with my neighbor's ability to use their backyard. It would have to be pretty severe in order really to be actionable, but that's really sort of what's captured here by that second prong, that it's unintentional but sufficiently negligent and sufficiently serious that it might therefore be cause a harm. Right? I'd be happy to take additional questions on that, of course, but let me move on here. Oops, I gotta. What happened? Oh, there we go. The unreasonableness component here of the first prong is addressed in ways similar to what you've encountered in the negligence context of your torts class, and that it is usually, I'm going to skip to this particular slide here, is addressed usually through some form of balancing of the harm and the utility of the conduct. And it is captured in one of the tests for addressing or analyzing the unreasonableness of that invasion of the neighbor's interest, or the person who's bothered, who claims the nuisance. It becomes unreasonable, the interference with the neighbor's or the property owner's use and enjoyment of their property becomes unreasonable when the gravity of the interference, the reason why there's interference, ends up outweighing, or the gravity of the harm of that interference, that the harm that is done to the property owner, the person who claims the nuisance, outweighs the utility of the activity that causes the nuisance to the person who engages in the activity that causes the nuisance. So it's essentially a balancing between those two parties, right? The person who's harmed and the person who causes the harm. And if the value of the activity that causes the harm outweighs the harm that the person who claims the nuisance, who suffers the nuisance, then unfortunately it's not an unreasonable nuisance, right? How do you determine that balancing? You look at these factors here on this particular slide: the extent of the harm, character, social value. Note here, by the way, that residential use of land is a very highly used, highly valued social use of property, as is, of course, industrial economic uses. But I would say oftentimes judges would certainly view living on a piece of property, using it for a residential home would be highly significant as an important social value. But other values on the other side might be, if you have a factory that employs a lot of people, pays significant taxes, creates a lot of jobs, has a significant positive economic impact, that of course weighs then on the utility of the conduct that causes the nuisance. Now, note here, by the way, that this test is biased in many respects in favor of large factories, right? Large factories, and biased against small landowners. If you are a small landowner, if you're a residential landowner sitting next to a large factory that really, really seriously makes it impossible to enjoy your land, you're in some ways really, to put it elegantly, hosed, because the economic value of that factory and the jobs that it creates would almost always or inevitably favor the entity that causes the nuisance. And that is really why the restatement actually has these other tests. That is, if harm is serious enough and the financial burden of compensation is not so serious to make the factory or other nuisance-causing activity financially infeasible, then the factory owner, the person causing the nuisance, has to pay. Right? Seems fair, and it's really sort of one of the safeguards whereby small property owners are sort of more protected under the restatement. And then finally, the third test is again a sort of a what one might sort of think of as fail-safe. That is, when the nuisance is so severe, you essentially, the property owner who is bothered or impacted is unable to use their property at all because the pollution or the interference is so serious that the harm is so severe that it should not be borne without financial compensation. Then financial compensation may be imposed regardless of the economic consequences. If you think about that, it sort of makes sense, right? If the harm is so severe, if the consequence is so serious that compensation would essentially make the factory or the activity causes the nuisance financially infeasible, makes it impossible for the business to operate, I think one might say the business should not operate because the harm that it causes outweighs essentially the economic benefit that it brings. And if that's the case, as a society, we really should not be endorsing that kind of activity, right? If business causes more harm than it does good, then it really should not be in business in the first place. All right, let me show you just briefly one other thing. I have a summary slide here that is a chart, a diagram. I'm not going to go through it. One last thing that I want to mention is private nuisances do have a threshold, and that is, in order for a private nuisance to be actionable, it has to be substantial. So something that's de minimis, something that's just somewhat bothersome. So if there's a slight odor from the neighboring bread factories, something that most people might deem to be pleasant, but some don't, it might be deemed to be de minimis and therefore not actionable. That would not cross the substantiality threshold, and therefore no ability to bring a private nuisance claim. Of course, if the harm goes beyond something sort of unpleasant or somewhat unpleasant, then and the question of whether it's substantial enough or not is, of course, a question that the court would have to determine. Right? All right. The last doctrine here that I want to touch on is public nuisance. Public nuisance, to some extent, is a misnomer or is misleading, at least in the way I'm sort of bringing it up, and that is, unlike private nuisance, it has nothing to do with property ownership. And that is really why I deem it, why oftentimes it might be confused. Public nuisance and private nuisance, beyond the name similarity, almost have nothing in common. Public nuisance here, as I define it in this slide, is essentially an unreasonable interference with a right common to the general public. It's really a broad range of interest that public nuisance protects. It has nothing to do with the use and enjoyment of property, nothing to do with land ownership in itself. And note, by the way, here, I didn't mention this earlier, but the overlap between property law and tort laws, of course, with regard to private nuisance and trespass, is that these are essentially torts committed against related to property ownership. That's where there's an overlap. Public nuisance has nothing to do with property ownership. Essentially an unreasonable interference with a right common to the general public. And note here that there is a threshold issue in that it has to be an unreasonable interference. De minimis interferences, for example, would not qualify. There's no property rights involved here. And the interference with the right common to, apologies, I've got to move this around. Right common to the general public here encompasses a broad range of interests. Interference with public health, public safety, public peace, public comfort, public convenience here. You can see that this is a broad claim here. A second set of issues here that's encompass interest is any sort of illegality, a violation of statute, ordinance, or administrative regulation, and also any kind of a condition here that is long-lasting and that has some sort of significant effect on a public right. Right? Oftentimes this arises when somebody's blocking a street, causing odors that bother community as a whole, not just a particular property owner, and may in fact be just or a violation of an ordinance or so. Those are all deemed public nuisances, and you notice here that is just the public nuisance doctrine really is a fundamental different nature than private nuisance. It has become important as a claim addressing climate change, all sorts of pollution, and other issues here. Now, one thing to point out is that public nuisance, because it is such a broad set of claims, lends itself and might be seen as something that is almost limitless in its coverage. Not exactly, but there is an argument to be made here. And if everybody could bring a public nuisance claim for whatever they deem to be an interference with public health, public safety, public peace, public comfort for that matter, public convenience, you can see how broad that is. It would essentially be unworkable, would allow essentially everybody to claim anything as a problem to them. And so how public nuisance therefore limits the use of this doctrine is by limiting who can bring a claim. And in general, really, public nuisance claims can largely be brought only by the government, but also by individuals who suffer a special harm. Right? So just because something bothers you, if it bothers everybody else, you have no special standing or right to bring a public nuisance claim. On the other hand, if you're somehow specially affected, and usually come back to this, the road blocking, if you live on that road, even though nobody can, everybody's bothered by a tree or by the blockage of the road, you are especially affected because if you live on that road, maybe you won't be able to go to your home. And so that would give you a special injury that would then give you standing. Now, the government may usually bring a public nuisance claim. There is a difference here, just a quick note here, between damages and injunctions. Usually injunctions require standing for injunction require to have the right to bring a claim for nuisances, for damages, but you also have to have some some ability to claim or bring a claim on behalf of a broader group, not just yourself. But as I said, of course, government officials generally have standing to bring a public nuisance claim. Right? This is a little longer than expected, but I'm going to stop here, and I would invite, of course, additional a question. Just to sum up here, 4 doctrines. Strict liability for abnormally dangerous activities, trespass, private nuisance, and public nuisance, all really foundational for environmental law, and really were the doctrines used by the courts, by governments, by government officials, and by private individuals to address pollution and other environmental degradation issues prior to the 1970s and the enactment of modern environmental statutes. These doctrines will continue to be important. They reappear actually. And one last thing that I would say, even in the presence of modern environmental statute, these doctrines act essentially as a background. So to the extent that statutes somehow have gaps, or they are for whatever reason inapplicable, these common law doctrines spring back into relevance and are relied on by environmental organizations, by government officials, and others then to address pollution and environmental issues. Thank you.